design. My name is Theo Blanas and I'm a building surveyor for the Victorian Building Authority within the Office of the State Building Surveyor. I'd like to begin by acknowledging the traditional owners of the land on which we meet and pay my respects to the elders past, present and emerging. Before we get underway, I'd like to run through a couple of housekeeping items. We have scheduled some time for Q&A later in today's session, and we encourage you to ask questions throughout the session. You can type your questions via the Q&A icon at the bottom of your screen, and we'll do our best to get through as many as we can following the presentation. I'd like to highlight, we will also be using the polling feature during the presentation. When this occurs, you will receive a pop-up on your screen with multiple choice answers available. You can submit your responses by selecting your answer and pressing the submit button. The greater the responses we receive, the more value we can get out of today's session, and it's important to note the answer to these questions are anonymous. Lastly, this session is being recorded, and as with all webinars, it will be available at the VBA website and YouTube channel. So in today's session, we continue the discussion on the role of the building surveyor and the role of the design practitioners during design and certification stages of proposed building work. This has been a consistently high trending topic in the industry, and it relates to the code of conduct that for building surveyors that came into effect on the 1st of January this year. The code reinforces the requirements under the Building Act for the appointment and the functions of the RBS and when carrying out their statutory functions. By extension, compliance with the code will also impact role and practices of practitioners engaged in the design of building work. To help interpret and navigate this important topic today, we are joined by Andrew Giolini, the State Building Surveyor, and Jeanette Barbaro, a construction lawyer and partner at Minter Ellison. So, okay, without further ado, I'll now hand over to Andrew and to say a few words on this and continue the presentation.
Thanks, Theo, and welcome everyone to the third instalment of VBA's education series for 2021. It's pleasing to see these sessions to date have been well attended by a range of practitioners with great engagement and feedback. We worked hard this year to substantially increase the delivery of educational webinars and resources for practitioners. Our masterclass series builds on feedback from industry, as well as matters of technical significance to educate industry, practitioners, building owners, and consumers. Education is fundamental to our regulatory toolkit. Improved access to valuable and contemporary education and resources for all practitioners helps improve a common understanding across industry. It addresses competency gaps, mitigates future disciplinary activity, and helps to develop public confidence in the expertise and performance of practitioners in Victoria's building sector. As Theo mentioned, conflicts of interest and the role of a building surveyor in the design of building work remains a key focus for industry. We continue to receive a high volume of inquiries related to this topic in the lead up to and since the commencement of the Code of Conduct for building surveyors. The VBA recognises that the code seeks to change behaviours and practices in some areas of industry, as well as supporting and reinforcing the important role of the statutory building surveyor. For some building practitioners involved in the construction life cycle, and not just building surveyors, there is a change required in the way they have operated, and that is why we continue to provide sessions such as this to deepen the common understanding. Your participation in questions also deepens our understanding of where clarity may be lacking or misconceptions may lie. I hope today's session will continue to promote constructive and critical thinking on matters of legislative interpretation, practical approaches to compliance, and identification and appropriate management of conflicts of interest. I look forward to joining you again later for the questions session, but now I'd like to introduce Jeanette Barbaro. Jeanette is a partner at Minter Ellison's in the Project Infrastructure and Construction Group. In addition to managing construction disputes, Jeanette leads the National Building Regulation and Compliance team. As a construction lawyer, Jeanette understands the technicalities of building compliance, as well as the legal risks and industry dynamics. Jeanette regularly advises builders, developers, investors, government and regulators in relation to residential and commercial construction, including the use of non-conforming building products such as combustible cladding. Jeanette, thank you in advance for today's presentation and welcome.
Thank you, Andrew. Thank you, Theo, and lovely to be here this afternoon with you all to discuss what I know from my discussions in the industry to be not only an interesting but somewhat often controversial question of conflicts of interest during the design process and the role of the building surveyor. The roadmap for today's conversation is going to be quite simple. We are going to, first of all, stop and look at the different types of building surveyors, taking it back to basics, because I think starting from basics is absolutely critical. In doing so, we're going to pause to also look at what the different functions a building surveyor can have. And in doing so, we will bring together those functions, those roles, and who can appoint the building surveyor to do those functions. We will then pause to look at what the building surveyor can and can't do under the Act, the Code, and also note the consequences of doing so. Now that's the first part of this session. The second part is where I'm going to need your help. In order to identify where to draw the line, we thought that perhaps the most useful way is to provide a various selection of scenarios that often crop up, and to have you interact in a Q&A poll, which I promise is anonymous, and have a go at answering what you would do in those scenarios. And then, of course, I'm going to tell you what the answers are. Now, I'm going to be cheeky with some of the questions. At times, there will be greys, because this particular area does provide a lot of doubt as to what you can do and why you can do it, depending on the scenario. But where we can provide guidance as to the best practice, having regard to what the Act and the Code now requires, that's what we're going to do. I'm then going to give you 6 takeaways, simple takeaways that you must remember each day, whether you are the builder, the building surveyor, the designer, or the owner. And then finally, the last part of this presentation is to bring back Theo and Andrew and to join together to answer some of the questions that hopefully you are thinking about as we go along and adding to the chat function. So let's get started. Let's go back to basics. What are the different types of building surveyors? Well, the first is the private building surveyor, and this is the individual that can be engaged to undertake building surveyor functions. And I'll come back to what those are in a moment. That individual has to be registered, of course, and can be engaged to undertake those functions as the registered individual. The second type of building surveyor is the corporate building surveyor. Here, it's the corporation that's being engaged. And yes, you can, as a corporation, be registered as a building surveyor, and yes, you can engage that corporation to provide building surveyor services. However, as you know, a corporation doesn't have eyes and ears and a mind. And so where a corporate building surveyor is engaged, they must have a designated building surveyor as an individual to perform those services. And that designated building surveyor also has to be registered. The third type of building surveyor is our municipal building surveyors. Now, they can be engaged to undertake some private building surveying functions, but principally, I call them the soldiers of council. They're employed or contracted or engaged by council, and they're primarily responsible with helping councils look after councils' backyards when it comes to building and enforcement. And then finally, the last type of building surveyor is the consultant or the advisor, as I call them. They're the ones that also can undertake building surveying functions of a particular type, but can't of other types. What are those functions? I see the functions in 2 buckets. The first are what I call the statutory functions. And I hate to bring up the law, but it's important to start here. The statutory functions fall within 2 sections of the Act, and only 2 sections. The first are what we call the Section 76 functions, and they are the statutory function to issue a building permit, to carry out the mandated inspections, to issue occupancy permits or to issue certificates of final inspection. If a building surveyor is appointed under Section 76 to undertake any of those functions, then they automatically get the functions in Section 77. And they are effectively all of the enforcement powers and all of the powers to make the discretionary decisions, for example, in relation to whether the 50% rule applies. So the appointment is to the Section 76 functions. The Act automatically gifts them the Section 77 functions. Now, just for the ease of language through this presentation, I will often be referring to the private building surveyor as the PBS. And where a private building surveyor is engaged, or a municipal building surveyor is engaged to do the statutory functions, the Act says we call them the relevant building surveyor. So at times I'll be talking about the RBS as well. The other bucket of functions that a building surveyor can perform are the contractual functions. Now, these ones are a little bit trickier. The contractual services that are consistent with the statutory functions that I've just been talking about are ones that a private building surveyor or a municipal building surveyor could be asked contractually to perform, but they fall outside their statutory functions. Now, there are two buckets because there are two types of functions. The first are those contractual functions that are not inconsistent with the statutory functions. And I've given on this slide an idea of what they may be. So, for example, some additional inspections that you might want the building surveyor to undertake, issuing a compliance report, or giving an opinion about a solution that's being proposed by the municipal building surveyor. The other types of contractual functions that a building surveyor is often asked to perform are ones that are inconsistent with their statutory functions, or they're not permitted technically by the Building Act. Some examples of that include input into the design, designing the performance solution, designing a compliant outcome, working within or alongside the design team, inspecting the works to ensure that design intent is being met during construction, issuing 238 certificates where the building surveyor hasn't designed the fire performance solution, and giving expert evidence. Now, all of those types of functions are inconsistent with the statutory functions or are specifically not permitted by the Building Act. So two buckets of functions, statutory, contractual, and then now let's look at who can appoint who for what. In relation to the statutory functions, the Act requires, as a matter of law, that only the owner or a person on the owner's behalf appoint either a private building surveyor, a private corporate building surveyor, or in some instances, the municipal building surveyor to undertake the statutory functions. That's Section 76 functions, the automatically acquired Section 77 functions, and any additional contractual services that are consistent with those functions. And I'm going to pause to repeat that again. Only the building owner or a person on their behalf can appoint a private building surveyor to undertake those Section 76 functions. There's one exception. The Act also says that for major domestic building contracts, the person on behalf of the building owner cannot be the builder. So what does that mean? Essentially in practice, that the building owner can appoint the private building surveyor to issue the building permit. As agent for the building owner for commercial works, a builder can appoint the private building surveyor to issue the building permit. For major domestic contract works, the builder as agent or on behalf of the building owner cannot appoint the private building surveyor to issue the building permit. In relation to the contractual functions, the rules are less rigid. Essentially, where the contractual services are inconsistent with the statutory function or are not permitted to be undertaken because you've got a statutory function, a private building surveyor, a private corporate building surveyor, or a consultant building surveyor can be appointed almost by anyone to do that, by the building owner, the builder, the architect, or any other person. In that regard, there's free contracting. But those contractual functions must not be undertaken if they've been also engaged to provide the statutory functions. So let's pause for a moment before I move on to the interactive session. The actual differentiation on a day-to-day basis about what a building surveyor can and can't do is driven by whether or not that building surveyor is going to be asked to or has issued the building permit, or is going to be asked to or has issued an occupancy permit or a certificate of final completion. If those are the roles that are intended or will be undertaken by a private building surveyor, then these contractual functions that appear on this slide must not form part of their engagement. So let's now focus on bringing all of that together and the role of the building surveyor, particularly the private building surveyor, when they're undertaking those statutory functions. And I'm going to start here, loathed as I am to bring up the law, but I think that it's important to understand that this is not just a statutory requirement in isolation, but the law has had occasion to look at this, and courts have said quite clearly that where a building surveyor is undertaking a statutory function, they play a critical role in maintaining public safety and protection in the design, demolition, and construction of buildings. And that responsibility requires independence and impartiality. The law recognises that an aberration exists because the surveyor is appointed by the building owner or someone on their behalf. But despite that, that building surveyor has to carry out a statutory function under which they are required to give an independent opinion, and they are called upon to give that independent opinion regardless of who has engaged them. It is that underpins what we're going to discuss next. So what does the Act not allow? A private building surveyor that has been appointed to carry out those mandatory functions of issuing a building permit, for example, or where a related person to a private building surveyor has done certain things. The first is that the private building surveyor can't be appointed if they or a related person has prepared the design or any part of it. Now, I know that most of you are thinking, well, what does that mean to prepare the design? Essentially, this is something more than simply saying that the design as designed by the designer complies with the BCA or the regulations. It is something more than simply assessing whether or not the design is compliant. It involves an involvement in actually developing the design or directing the way the design should go. If they've done that, then they ought not to be engaged to carry out the statutory functions. And in fact, they ought not to accept that engagement. The next is that if they or a related person is employed or engaged by the designer that is preparing the design, and their employment or engagement is to do more than the Section 76 functions, then they can't be appointed to carry out those statutory functions. The next is one that's often forgotten, and it's where the building surveyor was employed or engaged in the last 12 months by a designer to do more than what the Section 76 functions require. In those circumstances, the building surveyor should not carry out the statutory functions. Now, it's important to remember that if a person that is a related person to that building surveyor was employed or engaged in the last 12 months by the designer, then the building surveyor also can't accept the engagement. The next circumstance is where, again, the private building surveyor or the related person has a direct or an indirect pecuniary interest in the designer. They may be a shareholder, for example. They may have a panel agreement where they're a part of a panel and they're going to be chosen for projects that come up. that is not permitted. And if a private building surveyor is engaged in such conduct, or a related person is, then they can't accept an appointment for the statutory functions. Similarly, if they have a direct or indirect pecuniary interest in the building or the building works, they may stand to get one of the allotments at the end of the construction of a high-rise building because they know the owner. A no-no, they can't be appointed to undertake the statutory functions. And then finally, if they have a direct or indirect pecuniary interest in anyone that is carrying out the building work, that's the builder, the architect, or the person, the tradesperson. In those circumstances, they ought to also not be appointed to undertake the statutory functions. The Act also says that the building surveyor, the private building surveyor, or a related person can't carry out the statutory functions if there's a conflict of interest. The regulations also say that if there is a conflict, they have to immediately tell their client. The Act doesn't tell us what a conflict of interest is, but this is where the cases help us. And essentially, the cases have said that a conflict of interest is measured by reference to whether a fair-minded and informed observer might conclude that the decision maker may not be impartial. I've put up on this slide, and I'm not going to go through it, but the circumstances in which one can be a related person are immense. Being a partner in a partnership of a private building surveyor, being a director of a private building surveyor corporate company. It is important to ensure that you familiarise yourselves as to who related persons are, because this list goes beyond, I think, what most of us might expect it to capture. Aside from the Act, the code that's been introduced as of January this year also sets out requirements as to how building surveyors should behave. And in doing so, it relevantly talks about independence and conflict. I don't want to spend too much time going through all of these. The slides will be distributed. This is being recorded. You can take them away. But essentially, the code is not a new set of rules. What it is doing is putting meat on the bones of the rules that are set out by the Building Act, and does so by reference to examples. So when we think about the statutory obligations that I've just been describing as to when you can engage a building surveyor and what they can't do, the code informs what that means day to day in more detail. Essentially, it says you've got to be independent and you've got to appear independent, and you can't just be a mouthpiece for the builder or the owner's decisions. You have to make those decisions independently. There are a whole set of circumstances where you can't be the relevant building surveyor, such as being involved in design or advising the design solution or devising the performance solution. But you can be the arbiter of the truth when it comes to compliance, providing advice as to whether or not the deemed to satisfy solutions have been met, to also advise on whether the regulations and the BCA itself has been satisfied. The code also tells us that novation is a no-no, that a private building surveyor that is appointed to undertake the statutory functions shouldn't be entering into an arrangement that allows novation, whether it's a commercial building work arrangement or a domestic building work arrangement. And I know that many of you will have questions about that. We'll come to those in the last part of this session. Again, the design and what can and can't be done is absolutely critical. Separating oneself from the design process is essential. Avoiding being part of the design team, avoiding being engaged by the architect unless you are specifically only engaged for the Section 76 functions. And of course, performance solutions. It's okay to put your mind to whether a performance solution gets there or one is needed, but designing it, setting out the parameters of it, or even nominating who they should go to develop that performance solution is a no-no under the code. In relation to conflicts of interest, the code also makes it clear that a conflict of interest can be actual, perceived, or potential. It is not just actual conflicts that are caught. And that means that through the engagement, the private building surveyor has to be constantly asking themselves, Is there an actual perceived or potential conflict that may be arising or could arise? And will that mean that I might need to remove myself? The consequences. The consequences vary, principally for the statutory obligations that I described in relation to when you can be part of the design team or when a related person can be involved. Those are particular obligations that fall under 79(1) of the Act. And for those, you can apply for an exemption from the VBA. So if you're a RBS at the moment and you're feeling perhaps uncomfortable about what has happened in the past on a project you're currently involved in, and you'd like some peace of mind as to whether you should continue to act or whether you should remove yourself, you can always apply to the VBA for an exemption. Now, that doesn't mean you'll necessarily get it, but there is that avenue to allow you continue to act in circumstances where perhaps technically you should not be acting. The exemption, of course, must be in writing. But if you breach Section 79 or 79(1)(a), so the obligations that I've been talking about conflict and design involvement, they can lead to disciplinary action. Now, the ones in 79(1)(a) that I've described, they carry hefty penalties, but the conflict of interest one does not. It only carries the penalty of being subjected to disciplinary action. That is not necessarily a better situation to be in, but the consequences are different. So let's move to the interactive part of this session, and the one that I perhaps have been looking forward to the most. I'm hoping that you all will take the opportunity to participate. I will read out the questions. At the end of each question, the poll will come up and you'll have a period of time to answer and lodge your poll. It is anonymous, I assure you. Once the polling has closed, I will share with you not only the answer, but the poll results. So it'll be quite interesting to see what you'll think about some of these scenarios. Let's start. Question 1. Jane is a private building surveyor. She's been approached by SMIC Architects to enter into a consultancy agreement on behalf of the building owner. The scope of work is limited to issuing the building permit and the occupancy permit. Can Jane accept the offer and enter into the consultancy agreement? Yes or no? Let the polling begin. In the non-virtual world, it would have been nice to have some hold music now. Okay, the poll is closed. I'm hoping you can all see the results that I can see on my screen. The results are 54% yes and 46% no. And this, for me, indicates the challenge in the industry with a lot of these questions. They are often leading to these sorts of results in understanding. The answer to this question actually is that yes, she can. She can accept the engagement. She can be appointed as the relevant building surveyor by the architect, but provided it is solely for the Section 76 statutory functions, which are issuing a building permit, issuing occupancy permit, mandatory inspections. As long as it is no more than that, the architect can engage. Now, of course, you need to be sure that there is no perceived conflict of interest, but absolutely the Act allows her to be appointed in these circumstances. Question 2. SMIC Architects is not sure about a new ACP product they're thinking of using on the facade of a new high-rise building that they're designing. The private building surveyor that they're planning to issue the building permit in due course happens to be in their office, and SMIC asks him if a performance solution is going to be needed if they use these ACPs. The private building surveyor says yes, and offers to give up his afternoon at no cost to sit with SMIC and their team and help work out what the performance solution would look like. Can the private building surveyor issue the building permit in due course? Yes or no? Let the polling begin. Fabulous. Polling results, 11% said yes, 89%, a resounding majority, said no. And that's the correct answer. No. Even if the work is done for free, a PBS can't accept an appointment to issue the building permit where they have participated in the design, in whole or in part, of the performance solution. The concept of a performance solution can be discussed, but the actual preparation of it, even for free, and any supporting documents that need to be prepared, they cannot have the involvement of the RBS before, during, or during their engagement. Well done. Question 3. DevCo asked tick of approvals building surveyors to do some preliminary work to suggest design changes and develop design solutions to achieve deemed to satisfy compliance as the design was being developed. A year later, DevCo calls tick approvals and says, look, we need to issue a building permit. Can you guys do that? Tick of approval decides that they're going to get the new private building surveyor that just started working with them to do it. Can that new building surveyor that's just started working with tick of approval building surveyors issue the building permit? Yes or no? Okay, the results are in. 31% of you said yes, 69% said no. The answer is no. The new private building surveyor is a related party to tick of approvals, that is, that they're an employee. And tick of approvals were involved in the design beyond confirming whether or not the design achieved deemed to satisfy requirements. And so for both those reasons, both the tick of approval building surveyors of themselves or an employee of them cannot accept the appointment to issue the building permit. We have to bear in mind that there are multiple factors at play. Involvement in design is one, relationship with the building surveying firm that actually participated in the design is another. Question 4. Your architect's husband is a private building surveyor. Can you engage him to issue a building permit and the occupancy permit? Yes or no? Polling results, a resounding majority of no, 20% have said yes. The answer is no. The architect's spouse is a related party. They are the spouse of the designer who's preparing the design. And so therefore, because they are the spouse of the architect preparing the design, they cannot be appointed to issue the building permit. Question 5. DevCo hires SMIC architects to design a low-rise, high-density apartment block. DevCo appoints Jane, a private building surveyor, early on to ensure SMIC prepares a deemed to satisfy compliant design first time and on time, and also to issue the building permit in due course. Jane has monthly meetings with the design team. She reviews the design each meeting and tells them what is deemed to satisfy compliant and what is not. In those circumstances, can Jane proceed to issue a building permit when the time comes? Another one that shows how grey a lot of these issues can be. We've got a 52% have answered yes and 48% have answered no. The answer is yes. She has only advised along the way what is and is not compliant. She has not had input into how the designers should design. And therefore, for those reasons, she can accept the appointment to issue the building permit. Let's continue to follow Jane on this project. Before application for a building permit is made, Jane is asked to issue a BCA compliance report, setting out whether the final design is compliant with the BCA. Having issued the compliance report, can Jane now issue the building permit? Yes or no? Results are in. 59% have said yes, 41% have said no. The answer is yes, provided though the report simply confirms whether compliance is achieved or not. So you can have the RBS give you that advice along the way as to whether compliance is achieved. What they can't do though is tell you how to design that outcome. Question 7. DevCo has engaged SMIC architects to design a smart one-stop mini-city. The works include a link bridge connecting 2 existing residential buildings to a new mixed-use low-rise building and an adjacent retail centre connected by a covered walkway to each building. DevCo is worried that the 50% rule may operate, requiring the upgrade of the existing buildings to meet current BCA requirements. Jane, a PBS, is engaged to advise SMIC as to how to design the buildings to avoid the 50% rule and to issue the building permit. A year later, a building is appointed and Jane is novated to the builder and is asked to issue the building permit. Why should Jane cease acting? A, she designed to avoid the 50% rule. B, she was novated to the builder. C, she is not appointed on behalf of the owner. Or D, all of the above. Okay. I'm delighted to see that 80% have said D, because that is the correct answer. 11% have said A, 6% have said B, 3% have said C. You're all technically correct, because all of those reasons are the reasons why she should not accept the appointment. Question 8. DevCo wants to develop the next 7-star rated and tallest building in the Southern Hemisphere. SMIC architects are engaged following their win of a global design competition to help with the complex design SMIC engaged tick of approval to building surveyors to provide compliance advice as they develop the design, formulate the performance solutions, prepare a BCA compliance report for DevCo, and recommend modifications that can be brought under Section 160 of the Building Act to ease the compliance burden. Can tick of approval accept this engagement? Okay, 57% have said yes, 43% have said no. It's a bit of a tricky question. The answer to the question lies in what they have not been asked to do, not what they have been asked to do. The answer is yes. They are effectively consultant building surveyors only, and they've not been engaged to issue the building permit or undertake any of those other Section 76 functions that arise under the Act. For that reason, they can be appointed to undertake those contractual services, provided they are not being appointed to undertake the statutory functions, which is the case here. Question 9, DevCo is developing a commercial building in the CBD. Its demolisher, Smashco, applies on DevCo's behalf to a private building surveyor for a building permit to undertake demolition works. DevCo issues protection work notices to the neighbour. The neighbour disputes the protection works, and Jane, a private building surveyor, is engaged by Smashco to review the neighbour's response notice and to give expert evidence in the BAB appeal relating to the protection works. 9 months later, the relevant building surveyor was given permission by the VBA to terminate his appointment. DevCo, who now needs a new building surveyor, appoints Jane. DevCo withdraws the original building permit and a new building permit is issued by Jane. Is Jane's appointment as the relevant building surveyor valid? Poll results are in. 73% have said no, 27% have said yes. And the answer is no. In most circumstances, a very similar circumstance, I should say, arose before the BAB in 2014. And the BAB took the view that the work that had been done by Smashco was effectively design work. And Jane, having been involved to review that design work and to give expert evidence in the appeal, effectively became involved in the design work. Having had that involvement, she was not permitted to be appointed as the building surveyor to issue the building permit when she was brought on after the termination of the original building surveyor. I think also that had the original building surveyor simply transferred the appointment to her, she also would not have been able to accept that appointment. And finally, question 10, and perhaps one that is a little bit simpler than many of those that I've thrown at you this afternoon. As the landowner, you engage Jane, a private building surveyor, to issue a building permit to construct a set of townhouses. You and Jane both know each other as you both volunteer with the SES. Does Jane have a conflict of interest? Yes or no? The poll is closed. 61% have said no, 39% have said yes. And again, reflective of how tricky these are. I can tell you that an exact same circumstance was looked at by the court in Canberra in 2014, and they formed the view that there was no conflict of interest and that the building surveyor could act as the building surveyor to issue the building permit. However, it is tricky because now in this state we have the Building Surveyor Code of Conduct, and that Code of Conduct makes it clear that actual, perceived or potential conflicts of interest are not permitted. And it may be that this could give rise to a perceived conflict of interest. So in certain circumstances, it may be that, yes, she does have a conflict, but perhaps we can take that up with Andrew and Theo in the next session when we look at open questions from you all. Thank you for participating in the interactive. Let me wrap up with what I think are some simple takeaways based on the first part, which was a deep dive into what the rules and requirements of the Act and the Code are, and then the interactive session. The first is that the RBS, and remember that RBS is the building surveyor that is appointed to undertake those statutory functions of issuing a building permit, an occupancy permit, a certificate of final inspection, or to undertake the mandatory inspections, all of those things, as is often the case. The RBS must be appointed by the owner of the land or the building, or by someone on their behalf. But if it's a major domestic contract works engagement, it cannot be the builder that appoints on the building owner or the landowner's behalf. The second is that the RBS must be independent, must be seen to act independently, and must make decisions independently. They cannot simply be the mouthpiece of the owner and the decisions the owner wants to make, or the builder, or the designer for that matter. The third takeaway: don't get the RBS involved in design work. That is perhaps the simplest way to avoid any issues. What that means is that they can assess whether or not compliance is achieved, but they can't design the work to achieve compliance, whether it's deemed to satisfy or a performance solution. If you need design advice or support, whether you're a builder, a designer, an architect, or the client, engage a consulting building surveyor to do that. Keep that engagement separate to the building surveyor you want to approach, to appoint, to issue the building permit. Fifth takeaway: avoid novation. Now, I know this is a controversial subject. For many reasons, it has been what the industry has done. But if you can avoid it, avoid it. Finally, and this is important because we have a new set of rules in the code, and I often hear that the code is effectively a new law. It's not a new law per se. It supplements the existing obligations that are already in the Act and reflects what we should already be doing in the industry. But the important part is that now that it is a formal code that has been introduced, it will be monitored by the regulator, and day to day, it needs to be followed, as well as the obligations in the Act. Now, right on time, we're going to move to the Q&A session with Theo and Andrew. I'm going to invite them to join me now.
Thanks, Jeanette. That was very interesting and an informative presentation. In particular for surveyors to reinforce their role and turning their minds to consider managing their independence from design and any conflicts when they present themselves. So to the attendees, I encourage them to continue sending in their questions through the Q&A function. We can just kick it off. I can probably start asking a few now because we've got several. Let's start, I guess, with one of the questions. There was a question about question 8. Why can't a PBS subsequently be appointed as the RBS given there was no design input compliance advice? But is that something that we can have a look at?
So let's go back to question 8.
Yeah.
So the roles that this particular private building surveyor is undertaking is to provide compliance advice as they develop the design, formulate performance solutions, and then prepare a BCA compliance report. And then finally, to recommend modifications that are sought under 160. The infringing services that would not permit this particular building surveyor to be appointed to issue the building permit is the formulation of the performance solution. So being involved in the design of it. And then secondly, the devising what the modifications will be that are sought under 160. So that is stepping too far into the design to allow them to be appointed subsequently.
Yep. Okay.
Andrew, do you agree?
Yeah, definitely. I think, thank you for your presentation, Jeanette. I think really great. I think those questions really demonstrate the complexity of this space and the challenge we all have in trying to interpret it. And I think your last slide probably sort of summarises it, that because of the complexity, there's probably more caution required in this space, to err on the side of caution when you're making these decisions. That even though the code of conduct's there, that quite often these might end up in sort of court disputes, and if you're seen to be in conflict, then you're subject to the consequences out of that. And I think this goes, a lot of it sort of demonstrates the challenge of the interpretation around what is design. So I think definitely where you're formulating performance solutions, that is design. So you're interpreting the performance requirements under the building code, and then interpreting what will meet those requirements and sort of helping facilitate that. And so I think, yeah, totally agree.
Yeah, we're getting a lot of questions coming through about that matter. Like, for instance, we've got one that says, if you ask an RBS to clarify a building regulation when in design process, is that classified as assisting in design? And there's a lot of those type of questions coming through. So I guess there's an answer somewhere that says yes and no, depending on how far you get into it, like Andrew said.
That's absolutely right. Yeah. So in relation to understanding what the regulations require or what the BCA might require, that is absolutely an inquiry that can be made of the RBS. But to go further and have the RBS then be involved in what the design of that looks like in response to that clarification is the step too far.
Yeah.
Yeah, I like to use the words routine and general. So if they're sort of standard type questions, does it comply with the deemed satisfied, doesn't it? That's fine. But then where you take the next step and you say it doesn't comply with the deemed satisfy, and this is what I would do to, so then you're getting involved in the design, and you're meant to be providing a independent review of the design. So once you're actually providing the solutions, there's no one providing that review over the top. And so that's really the critical thing. It's how's this going to be perceived by someone who's not in the construction industry, the pub test, if you like. If they're expecting a statutory party that is reviewing the design documents in an independent manner, are any of these sort of things that we're looking at are going to be considered to be a conflict that might potentially influence their decision?
Yeah, the analogy I like to use is the football field. I see the certifier or the building surveyor as the umpire, and they know the rules. They're the arbiters of the truth in interpreting the rules. But I don't think any of us would be happy if the building surveyor, who's the umpire on a football field, was in the opposing football team's chambers before the game starts, with them around the table, strategizing how they're going to gameplay. That's too far. So to maintain the independency of the building certifier or the umpire on a football field, they've got to be removed from the players, and so that they can adjudicate whether or not a rule has been breached or not, or if a compliance has been achieved. So that, for me, that's how I see the role of the, more simplistically, of the building surveyor appointed to do those statutory functions. Can they stand there independently and assess what's been done as compliant or not? Or have they been in the room with the players and the coach, nutting out what the strategy is going to look like that they're going to bring to the field? That's too far.
Yeah, and I think the other sort of risk around being involved in the design, so providing some of those solutions or guidance, and even sort of doing a deemed to satisfy assessment at an early stage. So if you're doing a DTS assessment over a whole building design at a preliminary stage where there's not much information and you're only doing a high level assessment, if you basically give them an indication that complies, and you've only sort of spent a short period doing it, because only preliminary design, they go through their 6 months of design, give it to you to actually review in detail, and then you find issues with that design. There's a conflict there because you've given that initial advice, you've committed that it complies. You now find with the detailed documents that you may have missed something because of the preliminary assessment. Then there's a conflict there that potentially you're going to be influenced to let that slide because it doesn't make you look good because you've given that initial advice and they've gone down that design path. So it's really trying to avoid those situations where a building surveyor is put in a compromising position.
Yep. I think Jeanette's football analogy was a good one for the next question I had lined up, actually. So it says, I don't see how being a consultant surveyor for one project and then being engaged as a RBS, I guess you said PBS, but RBS for a different project is considered a conflict of interest, I presume with the same owner or agent. But again, it's the same issue where if you're strategizing and then next week you're also umpiring them, there is that conflict, isn't there?
Yes, and this is where the conflict of interest obligations are very different to those other obligations that are more specifically set out. Conflict of interest, ultimately at the end of the day, is a smell test. I know that's just a very simplistic way of putting it, but if you are the umpire one day and the next day you are in the room with the players and coaching them, etc., when you are playing as umpire, how is everyone else going to perceive you on that project? Will they see you as independent? Will they think that there is have the perception that there is a conflict because of the other role that you're playing? So it is necessary to manage the smell test or the perception by ensuring that, first of all, if you are providing both of those services, you clearly separate those services when you're advertising them. Say that you do one or the other, but you're not going to do those two together for any one client. Secondly, it's important that if you are acting on a project as the RBS, but the same players are on a different project, you're acting as the consultant, you need to be mindful about whether or not there is a perceived conflict that's created where you are the RBS, where you are the umpire. And you need to think carefully about whether you should be removing yourself because of the other work that you're doing with the same players.
Yep. Well, we probably have time for one more. If the designer is asking the RBS whether a certain area is part of the assessment, is that an issue? This is more related to working in small areas within the building and asking an RBS where do we stop design upgrade? That probably relates to that 50% rule, and I don't think that's an issue. I mean, the building surveyor will determine if it's 50% and the rest of the building needs to be considered, but it's not necessarily crossing over to design. That's establishing what the scope of work that needs to be reviewed rather than telling them how to actually make it comply.
Yeah, that's right. So the 50% rule is one of those discretions that building surveyors have that most of us wonder how on earth they make those decisions because they are so discretionary and quite subjective. Yeah. But it's really quite simple. The RBS, so the building surveyor that issues the building permit, that RBS can be asked whether or not the 50% rule is traversed. Absolutely. In fact, they ought to make that assessment as part of issuing the building permit. And that can be, you can ask questions to clarify whether that's been considered and whether definitively it can be disregarded or whether it has to be. But as to how you design to either avoid or how you design to meet the 50% rule, that's not a matter for the RBS.
Yep. Thanks for that, Jeanette. Unfortunately, we've run out of time on the Q&A today. We've got many questions still coming through, and we'll get to those, but unfortunately, we can't do it in the Q&A. I'd like to thank our attendees today for their participation in this session. And we further invite you to provide feedback via a short survey, which will pop up once the webinar is closed. This concludes today's session, and we say thank you to both Janet and Andrew for your involvement in the webinar and for a great presentation. And we thank you all for attending and taking part with questions in the polling today. A reminder that the recording of today's session will be available at the VBA website in the next few days. You may also register for upcoming events in the VBA Education Series on our website. So thank you again for your attendance and have a good afternoon.